Did you know a vape pen in Texas can be a felony? A lot of people think that vape pens are basically the same as marijuana, and the Texas legislature and some district attorney's offices treat it very differently. THC oil, wax, anything that's in a vape pen, one cart, that can be considered a felony offense in the state of Texas. If it's less than a gram, it would be a state jail felony punishable up to 2 years in a state jail facility. 1 to 4 grams is going to be a third degree, 2 to 10 years. So that means if you have a student who's in high school, they bring a couple vape pens they bought even at a store to school, then, and it doesn't have to be at school, they could just be pulled over on the road, they're going to have a potential third degree felony if they've got 1 or 2 carts and the officers weigh them between 1 and 4 grams. That is not a whole lot. 1 gram is like a sweet and low packet, like a little packet of sugar at a restaurant. That's about 1 gram. So anything more than that, you're talking 2 to 10 years. If it's 4 to 400 grams, it could be 2 to 20 years in prison. And so it's very, very different in Texas, the way they treat these waxes, these other THC products. If you know someone who gets charged with the THC vape case, talk to a criminal defense lawyer immediately, because each jurisdiction handles these a little bit differently. Another question we get is, what if I bought it from a store? Can I still be arrested? Yes, even if you bought it from a store. A lot of people think, well, I bought this legally from this store, I'm safe. Well, that is not correct. And there is a specific reason why. Delta 8, Delta 10, THCA, all these products are not listed specifically in the health and safety code in Texas. Possession of a controlled substance, penalty group 2, is defined. Like penalty group 2 itself has a list of substances, and under it is THC, tetrahydrocannabinol. And there is not a clear description of where Delta 8, Delta 10 falls. And so you may be asking yourself, well, why is it that these companies can sell this stuff to me? Why aren't they being prosecuted? I'm just, the purchaser. Well, the companies are getting basically permission from the Department of Agriculture in the state of Texas. They get consumable hemp product licenses, or they will get industrial hemp if it's more of a marijuana base, like leaf product. Then what they do is they use that license to shield them from prosecution. They have a written document saying they're allowed to possess these substances, that they've passed whatever percentage chemical test, and then forcing a actual test on them is just not feasible for the DA's office to continue to prosecute. They would face lawsuits. There's a lot of money behind that industry, but you, the consumer of it, typically do not have those same deep pockets. They will just make an arrest on that. And so they're attacking it from the demand side, not the supply side, which is a little backwards from most people's perspective. But again, you have citizens who are in this situation where they've been arrested. They really don't have any idea they've done anything wrong. That's where we can come in and help. Does it bar you from being prosecuted? Probably not. In different counties, they look at these things differently. So if you're in Harris County, they are not going to prosecute a possession controlled substance penalty group 2 case. Typically, they're just maybe not even going to be arrested. But if you're in Montgomery County, just a few miles north, then you could be arrested for a felony. They're going to prosecute it. You're going to be on bond conditions, which require you to report to a probation officer once a month to be drug tested. You have to call a phone number every day to see if it's your turn to be drug tested. There's a lot of different things that go along with being arrested for a felony. Besides just the potential of jail time, immediately there's going to be consequences to that. We have people who call us, they've been arrested out of state on these kind of cases, or they live out of state and they've been arrested here, and they're told, well, you can't leave the state. Well, we can help with things like that as well through what's called a motion to amend bond conditions. But ultimately, what we see is most of these THC cases with a vape pen are between people between the ages of 15 and 26 or 7. And if you have been arrested for something like that and you're in that age range, probably the most critical thing for you is to try to avoid that becoming a felony conviction that goes on your permanent record. And your record is a lot of different things. People don't typically understand that your record is a series of documents over multiple different police agencies. And the only way to get rid of those things is through an expunction. And the only way to be eligible for an expunction is to get the whole case dismissed. So having counsel on your side is a really important thing when you have this kind of case, especially for a young person. So how much THC turns into prison time? Well, less than 1 gram is a state jail felony. So any amount of THC product that you have on you, period, is a state jail, unless it is only the plant cannabis sativa L. If it is only that plant, then it's going to be a misdemeanor possession of marijuana. But other than that, a wax, a vape pen, a gummy, anything like that, automatically a felony, any amount at all, even less than 1 gram. State jail is a little bit different than the Texas Department of Criminal Justice, which is the prison system. 1 to 4 grams is a 3rd-degree felony. That's 2 to 10 years in prison. 4 to 400 grams, 2nd-degree felony, 2 to 20 years in prison. And then over 400 grams is a 1st-degree felony, which is up to life in prison. And they don't actually have to prove that you used the substance. They only have to prove you possessed it. And that's why defending these kind of cases really matters. So what is the number one defense in a drug possession case? Most people think drug cases are about the drugs. They're not. They're normally about the search itself. If the police have violated the 4th Amendment, then evidence may be able to be suppressed. And that means the prosecutor will have no case left. Challenging the traffic stop or the reason behind the detention is one of the most powerful defenses we have in a drug case. That's why every drug case needs to be examined carefully for illegal searches. If you think a vape pen is basically the same thing as marijuana, you might be in for a huge surprise, because in Texas, a vape cartridge can get you turned into a felony drug charge really, really quickly. So what is penalty group 2? Texas organizes drugs into categories called penalty groups under the Controlled Substances Act. And one of those categories is penalty group 2, which includes things like THC oil, marijuana wax, MDMA, ecstasy, and other synthetic compounds. And most people are pretty shocked when they find out that THC oil is treated differently from marijuana itself. Marijuana flower might be a misdemeanor depending on the amount, but THC is distilled from wax or cartridges, and that can be immediately a felony. Again, the punishment ranges for things like this. It's less than 1 gram is a state jail felony, 6 months to 2 years in state jail or probation. 1 to 4 grams is a 3rd-degree felony, 2 to 10 years in prison or probation. 4 to 400 grams, 2 to 20 years or probation. And then over 400 grams, a 1st-degree felony, up to life in prison. And the prosecutors do not have to prove you were selling this substance. Possession of the substance alone is enough for a felony charge. So why do people get arrested even when they purchased it legally? One of the biggest misconceptions is that I bought this at a vape shop, I'm not going to get arrested. That does not protect you. The police can't determine the THC concentration instantly during a drug traffic stop. And so the officer believes that the cartridges contain THC. If that's true, then you can still be arrested and charged, even if it's marked Delta 8 or Delta 10, or if it's even marked less than 0.03%. If they're not sure about that, they'll do this test, and people are getting arrested for this regardless of whether or not they think that amounts. If you and I think that amounts to probable cause, judges in Texas are holding that to be probable cause. Drug possession cases often come down, though, to how the evidence was obtained. Illegal traffic stops, unlawful searches, the lack of possession or knowledge, or weak forensic testing can all be issues that we use to try to win a case like this. If the search by the police violated the 4th Amendment, the court can suppress the evidence and the case may totally collapse. So if you or someone you know has been arrested for THC with a vape pen or other drug offenses, you should speak with a criminal defense lawyer immediately. Drug cases are often dependent on technical legal issues that can make a difference between conviction and dismissal.